My boss fired me 3 days before my bonus was due. He called me into his glass office, said the words with the same flat voice he'd used for years when he wanted something made to sound like routine, and told me they were restructuring my position. That phrasing stung because the week before he'd told me, with a smile, that my bonus was already in the pipeline, a line I'd repeated to my landlord, to my accountant, to my mother when she asked whether I could cover the dental work she'd been putting off. He took the bonus by taking my job first. He was Mark Taylor, smooth, precise, the kind of man who had been promoted on quiet competence and the right friendships. He hired me 7 years earlier as a project manager and had been my advocate at review time until he wasn't. I don't like the word betrayal. I prefer sharper facts. But he betrayed the quiet trust that keeps small companies functioning. The trust that someone who has been on your side for years will not cut the rope when you need it most. I say cut the rope because that was the moment I felt vertigo. Concrete things were at stake. My mortgage payment, which was due in 9 days. My daughter's college deposit, which would be billed a week after that. A car lease that had one payment left before I could refinance. And my mother's prescription bill, which I had promised to cover while she recovered from surgery. The bonus was $28,500. Not an obscene number, but enough to steady 4 fragile things at once. Lose it, and everything shifts. The setup is ordinary and precise. I was senior operations director at a mid-sized software firm headquartered in downtown Charlotte, occupying a floor with glass walls, potted ficus, and framed photos of CEO speeches. My job title meant I was the person who kept the trains running. Billing, vendor contracts, client escalations, payroll exceptions. People came to me when payroll messed up or when a client threatened to walk. I had an institutional memory that mattered. I knew where the paper clips were, and I knew which client on any given quarter could implode if a contract clause was misread. Mark had brought me in for my steadiness. He also had the ear of the majority shareholder and the chair of the board, a man named Arthur Whitman, who was 56, owned 62% of the shares, and liked golf better than trouble. Mark and Arthur had a private understanding about how things were run. I was never a party to that understanding. I was a reliable executor. Dependency wasn't just about the bonus. I had a 2-bedroom condominium with a 30-year mortgage and a small but stubborn equity line that covered home repairs and my mother's medical co-payments. My daughter Leah was a sophomore and had applied to a summer lab program that required a non-refundable deposit. I had an older student loan that was already on income-based repayment and a dog that had half a Maine Coon personality and a very expensive vet record. I had a laissez-faire landlord, which was convenient, and a car lease that stubbornly refused to be cheap for a woman who drove clients and prototypes across the city. My income was not luxurious, it was steady. That steady income had been what allowed me to plan. I couldn't simply leave. This is one of the things that we, those of us who keep chapters of our lives tidy because there is a mortgage and a sick parent and a child, rarely say out loud. When you have obligations, your options look like smaller rooms inside the same house. Leaving would mean breaking the chain on things I had promised people, and those promises were important in ways that had nothing to do with pride. Mark knew that. He knew exactly the rhythm of my payments because he'd asked for a line item breakdown of the project budgets last quarter, and I'd given it to him. He knew intimately what would be destabilized if he removed the money at the wrong time. It made the action feel deliberate even before I had time to articulate motive. The first escalation wave arrived quickly and in a way that felt shockingly administrative. The company's internal systems were switched off to me the morning after I was told I was no longer needed. My email bounced. My building access card deactivated. The project dashboards I had curated for years redirected approvals to Mark's account. The clients I had nurtured suddenly received messages from him that reassured them everything was under control. I had to call my account bank from my cell phone to confirm that a salary deposit scheduled for the first of the month would not be delayed. It arrived, but the bonus, which the payroll calendar said would be paid on the 15th, was missing. I called HR. The woman in HR used the company's neutral language. We don't comment on individual compensation decisions, but you can submit a written inquiry. The written inquiry netted an automated reply that the company was reviewing compensation matters. When I asked the CFO at dinner, he looked at his napkin, uncomfortable, and said Mark had recommended the restructure. When I asked Mark, the man who had been my mentor and, for better or worse, my arbiter, he smiled the way someone smiles when they want to seem in control and said, "We had to make adjustments. I know it feels sudden." He called it a change. I called it being rendered irrelevant 3 days before a sum of money that I had been assured was mine. My immediate reaction was procedural and practical. I gathered my employment contract, old performance reviews that had praise for leadership during Q3 rollout, and emails where Mark had promised that the bonus was approved. I printed documents, wrote a letter to payroll, and asked for an itemized justification for the withheld payment. The act of gathering calmed me. Organization always does. The consequence of that practical reaction was immediate humiliation. Within 48 hours, Mark sent a terse company-wide message about restructuring for efficiency, and someone on the third floor, someone who had been friendly to me because we had once celebrated a client's renewal with mid-afternoon champagne, stopped making eye contact in the hallway. Then the second wave. Mark began to press on the financial strings we had in common. He reassigned a major client, the one whose software license renewal would have paid for the pending deposit to Leah's program, to his office. He curtailed my access to vendor contracts, which meant I couldn't finalize certain discounts that the team had promised. He also started to push a narrative that my role as an operations manager was being consolidated because the company needed a more centralized leadership approach. People used the same sanitized phrases Mark used. The consequence of that language was twofold. Clients received a story that we were becoming more decisive, and I received, in whispered corridors, suspicion that I had somehow been the weak link. Rumors started that I had let things slide on a late vendor payment 3 months prior, a small error that I had corrected weeks before. The rumor carried with it a staining implication. If I could be careless once, perhaps I could be careless always. It reduced my credibility. I tried escalating to the board. I requested a meeting with Arthur. That meeting ended with Arthur saying that Mark had handled personnel matters and that the board trusted his judgment. Arthur is a man who thinks in quarterly cycles and golf handicaps. When someone frames something as a personnel matter, it becomes, in his mind, a 3-line note on a spreadsheet rather than a human consequence. That response was another betrayal. the board's trust in Mark over me despite my tenure and the contracts I had managed. The consequence of board silence is subtle and corrosive. When governance rests on personal relationships, the person without those relationships is at risk, however justified. My reaction grew more private and vindicated them formal. I called a labour attorney for a consult and discovered that the company's handbook had more language protecting employers' rights than it did employees. She told me bluntly that at-will employment in our state meant they could let me go, and that unless I had a signed promise or evidence that my termination violated a specific law, I was likely to lose a standard lawsuit. I remember sitting in my car in the driveway, phone fading to silence, the lawyer's voice still in my ear. You can try a claim, but it's expensive and success is not guaranteed. So I pivoted toward leverage. If legal protections were thin, corporate paperwork might hold a more brutal fairness. Corporations always leave traces. There are bylaws, board minutes, audit trails, vendor invoices, signatures in PDFs. You can always find a paper trail that reveals whether someone actually followed process. I thought logically of what I had access to. I had been operations director. I had handled contract approvals. I knew where certain files lived. Mark, being efficient and confident, did not clean up everything. The third escalation wave arrived in the form of exclusion and humiliation. 2 weeks after I was fired from my role, a company holiday party included a small award that historically recognized operational excellence. Mark accepted it. He said words about teamwork and execution that felt, from my vantage point, like an erasure. Co-workers who had once called me at odd hours to ask, "What would Claire do?" now avoided the subject. In staff chats I had nurtured for years, new messages began to omit my name. On LinkedIn, Mark posted a photo of me at a conference 6 months earlier and called me a trusted advisor in the past tense. It tasted like theatrical betrayal, the public removal of presence. My reaction hardened into action that was silent but meticulous. I began an inventory. I opened an old email thread with a vendor who had billed us incorrectly. I opened a negotiation folder for a client for whom Mark had promised a 2-year extension in exchange for an early payment, a clause that would have impacted the bonus pool. I printed the chain of command and the corporate bylaws that had once seemed abstract. I found something small and sharp, a requirement in the bylaws that any change in senior compensation be ratified by a compensation committee and recorded in the minutes. Those minutes needed signatures. Someone had signed them, apparently Mark, but the signatory process required 2 board members' initials. Only one set of initials existed. The discovery felt like a splinter of light. It didn't resolve my problem, but it suggested a vulnerability in Mark's managerial choreography. If the signatures were incomplete and a required committee had not actually ratified the change, then the withholding of the bonus might be procedurally unsound. I drafted an email to the HR director and CC'd the CFO and Arthur, laying out the timeline and asking for a copy of the compensation committee minutes. I attached the contract where my bonus metrics were spelled out and the email threads where Mark had previously congratulated me on meeting targets. I was careful. I wrote as though I were asking for nothing more than documentation. Their response was a short, "We'll get back to you," which in corporate speak can mean everything and nothing. But then the situation escalated in a new direction. Mark accused me of copying confidential documents. He emailed IT and complained that I had accessed files after my appointment had ended. IT responded by forwarding an audit showing that my credentials had not been used after deactivation. The allegation had been false, but it reintroduced a smear. The smear had a consequence, an internal HR advisory that I had violated proprietary information protocols. It was not an actionable offence, but the stain on my record helped justify the action they'd already taken. The day after that advisory, one of my mentors from an industry association texted and apologised for not reaching out sooner, a way to say he would not be involved. I reached the low point in the tale of small cruelties and bureaucratic attrition after the company mailed a letter that felt heavy because it was simple. The letter said that because my status with the company had changed, they could not reissue previous approvals for short-term loans and benefits that had been contingent on payroll. The bank that had been processing my home equity request withdrew their offer because they needed a 6-month history of bonus payments to underwrite. My mother called to ask whether we could postpone some of her post-surgery treatments, and I, for the first time in a long time, could not promise. Leah called to tell me that the summer lab had been given a second round of acceptances and mine required the deposit. The low point was not thunderous. It was a quiet, furniture-moving kind of grief. The feeling of boxes in a house settling into new places because something structural had been removed. The leverage I had, a history of good work, relationships, the patience of a board that favoured stability, evaporated beneath me. I felt trapped, small, abandoned, and the world of things I'd arranged for others was now the world that could be lost because of a single withheld check. The turning point was an accident, not a revelation I staged. It was a mistake in a file that someone else made, and mistakes have a blunt honesty that suits justice. In the course of collecting emails, I found a subfolder in the shared drive that had been tagged Legacy Compensation. It contained PDFs and minutes from the past 3 years. A junior accountant, new to the firm and prone to optimism, had misnamed a file. Inside, I found a scanned copy of the Compensation Committee minutes for the quarter in question. The minutes were incomplete, but an attached PDF, a signed approval document, was dated 2 days after my firing. That alone would be inconvenient. But deeper in the file was a legal form I had never seen before. A corporate resolution stating that any substantial alteration to an employee's compensation scheduled within 30 days of a dispersal must be pre-approved by the Executive Compensation Committee and the chair of the board. The resolution had a signature block. On that block, the chair's signature was present, but not the committee chair's. Someone had scanned an unsigned page and included it in a document that claimed completion. The error didn't make the truth immediate, but it made it contestable. There were no dramatic confrontations, no shouting. I took the scanned files, burned them on a thumb drive, and went to see Arthur. I did not tell him about the bank letters, or the dental, or the summer deposit. I did not cry. I laid the documents on the table. I spoke in short, precise sentences. I said, "These are the Compensation Committee minutes. They show the bonus was scheduled and that required approvals are missing. I want a review." Arthur read them, his face moving from mild annoyance to surprise to a small, guarded concern. He asked where I had found them. I said I had been looking for documentation, and these were on the shared drive. He called a meeting, What felt like a legal loophole was not cinematic. It was procedural. The bylaws contained a clause that if the compensation committee had not been properly constituted, certain approvals could be deemed invalid. The company had a governance policy that required all compensation changes be transparently recorded. If they hadn't been, then the withholding could be adjudicated internally. The loophole was that the company had not followed its own rules, and those rules were a governance mechanism, not a favour. Complicated things happened in quick succession after that discovery. Arthur asked for an independent audit of the compensation committee's minutes. The audit flagged irregularities. The board convened a special session. The audit also found misallocated expenses on Mark's line. Nothing criminal, the auditor said, but enough to trigger a formal review. Mark responded by reaching out to a lawyer and suggesting malicious access to files. The lawyer's email was polite and contained legal terms that felt like pressure. I sent my own lawyer a summary and the digital copies. He told me to be ready for counterclaims. The consequence of invoking the bylaws was immediate. The board, faced with procedural failures and irregularities, had to act. They called an emergency session and voted to place Mark on administrative leave pending an investigation. The motion was not framed as a personal victory for me. It was framed as a necessity to protect company interests. That phrasing was bureaucratic and, in a way, merciful. It made my elevation less about me and more about the company's continuity. The motion also appointed an interim operations head to maintain stability until investigations concluded. Arthur looked at me in the meeting and said simply, "We need someone who knows the systems." I had lived by those systems. The board appointed me interim director. I did not expect to feel triumph. The appointment had a metallic taste. It felt at once like rescue and like the opening of a new job with bigger demands and fewer allies. Mark's leave was administrative, not a finding of guilt. He contested every accusation. He sued the company for defamation. He called me in emails the lone agitator and the one who would not let go. A world opened where career moves dragged into legal territory. But the board had to choose between the certainty of a functioning operations head and the uncertainty of letting the company drift while investigations continued. The loophole I had used was not magic. It was a procedural requirement that they had to honour. The consequences of taking his job were immediate and layered. First, the financial thing. The board asked the compensation committee to rectify pay discrepancies if found. The auditors recommended that withheld bonuses be placed into an escrow account until the conclusion of litigation. The bonus money was not in my hands immediately. It had been frozen to prevent the company from appearing to favour one side in a dispute. That was pragmatic and fair in a way that didn't feel like consolation. Over the following months, the audit resolved parts of Mark's expense accounts and found that some discretionary spending had not been properly authorised. The board, in a meeting where the air smelled faintly of stale coffee and the lights were too bright for late afternoons, voted to reallocate a portion of that money to cover withheld bonuses. It covered most of mine, not all. I went to the bank and explained the situation. They extended my line in a way that was stricter than before, but enough to meet immediate obligations. Leah's deposit was saved. My mother could continue with treatment. Emotionally and socially, the consequences were deeper. People were resentful. Colleagues who had been friendly to me before now either avoided me or treated me as a test case. There is a peculiar social loneliness to being the person who uses organizational rules against those who formerly smiled at you in the hallway. Some whispered that I had ambition that showed itself at the wrong time. Others congratulated me carefully as though they were speaking to someone who might fracture. Meetings were icy. I sensed that some of that distance was protective. Humans are tribal, and tribe members who change relative positions induce anxiety. There was also the practical consequence of taking a job I had not planned for. Operations, as interim director, became a night daily presence. Contracts leaked, deadlines shifted, and clients wanted reassurance. I found myself in conference calls at midnight, arranging payment plans, convincing vendors to accept staged settlements. I had 1,000 small decisions that mattered to people I didn't know and things I was responsible for because they used to be mine and then weren't, and then were again. Mark's lawsuit was a constant shadow. He alleged defamation and wrongful removal. His lawyer's letters accused the board of colluding and suggested that my discovery had been opportunistic. The company defended its process. The board emphasized the audit and the missing signatures. Litigation costs mounted. I slept poorly. I had an ache in my shoulder that wouldn't go away, and the kind of fatigue that comes from being the person who is always the last to leave the room. The moral clarity I had hoped for after exposing procedural irregularities did not produce a neat, comforting end. Mark did not vanish. He fought. He said things to mutual acquaintances that were cruel and ballasted in self-preservation. The leveling over time was not about revenge, it was about repair. As interim director, I had the authority to propose a budget cut that would make the payroll solvent for the coming quarter. We renegotiated vendor terms. We offered small severance packages for 2 contractors whose roles had been redundant under the new structure. I learned to make decisions that felt like triage rather than triumph. I redistributed some of Mark's discretionary funds to client retention efforts. I set up a compensation committee charter that made the ratification process more transparent. I ordered that minutes be signed in triplicate and archived. The governance loophole that had been exploited in one direction was now closed in the other direction. The company, practical and profit-minded, preferred predictability to drama. That meant my reforms, mundane as they were, had an impact. I paid costs, I lost friends, I learned who would stand close in the storm and who would not. Some voices receded and others, slower and surer, arrived. The CFO who had been cautious stayed. A young project manager who had been hired the month after I was temporarily relieved became a steady ally. Leah, who watched the edges of my exhaustion, hugged me in the kitchen one night and said, "You did the right thing, Mom," which was both an unburdening and a complication. Children are simple truth tellers, and their certainty can simultaneously comfort and weight your decisions. The low ongoing cost was not legal, it was relational. The boss who had fired me before the bonus continued to insist publicly that he had been wronged. The lawsuit dragged on for nearly a year before settlement talks began. Settlements are not confessions, they are the law's version of a truce. We agreed to a non-admission settlement that released both parties from further claims. I received a portion of what had been withheld and the title that had once been my day-to-day focus. Mark moved on to a startup and announced in a press release that he was excited to explore new opportunities. He left a few slivers of bitter commentary on professional social networks, which made my job harder in reputational terms, but did not alter the tangible work I had to do to keep the company functioning. The most unexpected consequence was internal. I underestimated how being elevated would change me. For years, I had been in a role of support, facilitating, editing, arranging. The new role required a forward posture, making decisions that would impact people's salaries and careers, not just their schedules. There was small torment in determining how to handle layoffs, how to speak to contractors whose contracts expired, how to balance fiscal prudence with human dignity. I made mistakes. I apologized when due. I learned to let go of the idea that leadership meant never making a wrong call. It meant making the right call within imperfect constraints and being responsible in the aftermath. There was, finally, a quiet redemption, not of revenge, but of integrity. The company instituted the governance reforms I had advocated. The compensation committee was formalized with external advisors. We agreed to an outside compliance auditor who would review expense reports quarterly. I set up a small employee resource group for operations staff so that their concerns would be heard. Some of these changes were because I had to be pragmatic. Others were because I kept thinking about the small indignities I had endured and how they could be prevented for someone else. I did not do this to make myself feel noble. I did it because, in practice, the smallest shifts in process either protect or expose people. I had been exposed. I did not want others to be. In the end, I had Mark's job because I found a procedural fault line and pushed into it. I did not steal anything with drama. I used a company's own rules and the sloppiness of those who trusted their own competence to shield them from oversight. That is not a heroic tale. It is an administrative one. It required patience, careful documentation, and the willingness to enter rooms where the conversation was uncomfortable and stay there until the board had to choose stability over convenience. I will say this plainly, if you are looking for cinematic vengeance, this will disappoint you. There was no triumphant music. I did not dance on Mark's invoices. I did not gloat. I accepted a job that carried costs I had not imagined. I had to negotiate respect, manage pain, and pay for professional help to handle the lawsuit. I lost some friends. I found others. The bonus I was supposed to receive was awarded partially, and not with the fanfare I had imagined. It was enough, in the practical sense, to keep the mortgage current and to register Leah for her program. I slept better after the company corrected its processes, not because of vindication, but because the world felt less arbitrary. Today, I still go into that same glass office. The ficus have been replaced twice, and the photos on the wall are different. The job is heavier in responsibility and lighter in the illusion of informal loyalty. I keep the bylaws folder on my desktop and a paper copy in a drawer. I have learned to expect both competence and negligence, and to trust the process when it is applied equally. I have learned that people's worst behavior often reveals the need for better systems, and that systems can sometimes be used to restore balance. If there is a final thought, it is small and unadorned. People will hurt you sometimes, not because they are monsters, but because their incentives align that way. Institutions will amplify that harm when they prefer convenience over rules. And there are moments when the only recourse is to use the institution's own architecture to correct a wrong. That correction is messy and can cost you more than money. It can cost you friendships and quietness and the ease of not having to explain yourself. but it can also sometimes restore the arrangement enough that other people's lives are steadier. That felt true for me. If you made it this far and this struck a chord, please leave a like. If you want to hear more stories like this, subscribe. And if you've ever had to fight a quiet, procedural unfairness at work, tell me in the comments. I'd like to know how you handled it.